shown later on down the road. So essentially then, Mr. Ingelson's asking the court under 2.118 to amend, obviously after the 14-day by right, so asking for leave. And I know the court is well aware of what the case law says when asking for that justice must require that be allowed. And clearly this is not one of those situations. This is clearly a futile attempt. According to the case Ganya v. Motor Parts Federal Credit Union 192 Mishap 74 on page 78, an amendment is futile where, ignoring the substantive merits of the claim, it is legally insufficient on its face. That's precisely what we have here. And Mr. Pliska should not be allowed to use the court system, our civil system, in this manner. And he should know that going and filing a complaint that looks like this has consequences. And those consequences are that he doesn't get to come back later and try to clean it up. He doesn't get to come back later and throw more things at the wall to see what sticks, because ultimately the only person that's literally paying is Ms. Latier. As noted, I know there's quite a lot of different arguments that I've made, different requests that I've made, but again, this case should be nipped in the bud right now. It should be dismissed with prejudice. It should be deemed frivolous by the court, and Mr. Pliska should be on the hook to pay for Ms. Latier's costs and attorney's fees.
Can I ask you, in terms of, I mean, as I understand it, Mr. Ingelson is relying on the rule, not so much of leave to amend, the normal leave to amend, but the summary disposition rule that says, if I agree with you, as seems everybody agrees, that the complaint as filed was inadequate and summary disposition should issue. The court rule does say that if I'm going to enter summary disposition, I should allow the party against whom that's entering an opportunity to amend the pleadings, unless doing so would be futile. And what am I to make of the fact I'm sympathetic to your arguments that the claims for an interest in the property are at best going to be a stretch and a very difficult burden for Mr. Pliska. But Mr. Ingelson's response also says he wants to press claims for a return of items of personal property, almost like a claim and delivery. I mean, that wouldn't be